Lex non rege est violenta. The law must not be violated even by the king. Hello and welcome to LicitElite. You're watching third episode of Criminal Law Lecture Series by LicitElite. As discussed in our last video, today we will talk about extent, structure and important amendments to IPC 1860. Friends, as we have discussed in our last episode, Indian Penal Code was passed under the chairmanship of Lord Macaulay. The Indian Penal Code was passed by legislature on October 6, 1860 and it came in force from January 1st, 1862. It is unfortunate that Macaulay didn't survive to see the penal code he wrote come in force and having died near the end of 1859. The code came into force in Jammu and Kashmir on October 31st, 2019 by virtue of the Jammu and Kashmir Reorganization Act 2019 and replaced the state's Ranbir Penal Code. So it applies to whole of India including state of Jammu and Kashmir now. Let us talk about the structure of the code. It consists of 23 chapters and 511 sections. Indian Penal Code, we need to learn two things about Indian Penal Code, that it consists of general principles and specific offences. Now further, specific offences are divided into two parts, in-kind offences and kind offences. In-kind crimes or offences are basically incomplete crimes and are acts involving the tendency to commit or to indirectly participate in a criminal offence. The general in-kind offences are described as in-kind offences of attempt, conspiracy and incitement, but they are not self-contained offences. Let us learn how to read each section of Indian Penal Code. We shall start with learning the definition. Then explanation, heading towards illustration. We need to understand the illustrations. Then we need to head towards punishment prescribed. So there are two main parts of Indian Penal Code, general part and special part. General part deals with principles and doctrines. It includes principles of criminal liability, defenses of criminal liability, rules related to punishment, and doctrines governing preliminary crimes. The other part is the special part, which deals with specific crimes. It includes rules defining individual crimes and prescribing punishments for them that apply the general principles and doctrines to particular crimes. So, if we see the structure of Indian Penal Code, we find that there are two things. The jurisprudence of Indian Penal Code or the general principles, which include general explanation, concept of liability, punishment, general exceptions, and court offences. If we see the second part, that is specific offense, it contains offenses against state like war with friendly neighbor, sedition, assaulting high officers, escape of state prisoner. Second thing of specific offenses against society, the public order like unlawful assembly, rioting, nuisance, etc. Thirdly, there are offences against person, against the body of a person, against property, against reputation. If we talk about the crimes against a body, they are, for example, hurt, assault, kidnapping, abduction, homicide, rape. If we see the offences against property, they are theft, extortion, robbery, dacoity, cheating, etc. There are some crimes which are against the reputation of a person. For example, intimidation, insult or defamation. Friends, now let us talk about the amendments in IPC. The code is universally acknowledged as a cogently drafted code ahead of its time. It has substantially survived for over 160 years in several jurisdictions without major amendments. So far, it has been amended around 77 times, and the major amendments and important amendments were that of 2013 and 2018. Let us talk about the Criminal Law Amendment Bill 2013. It is also known as Anti-Rape Bill. The act came into power on 3rd February 2013 after the outrage of whole country behind the homicidal gang rape that occurred in New Delhi the evening of 16 December 2012. This amendment provided a new definition to the offence of rape, and many other sections were added from section 354A to 354D. The Criminal Law Amendment Act 2018 is additionally a result of such primitive occurrence which shook the conscience and inner voice of the whole country. The demand for making stringent to rape laws more stringent had begun creating because of different youngsters' assault episodes. The notorious Katua rape case and the Unnao rape case set off this demand, and this brought forth the change of 2018. After the amendment of the revision, Section 376 deals with 3 classifications of punishment for assault aside from assault of ladies by police officials, community workers, members from the military, and so forth. Thank you for listening patiently. We will come up with our next chapter on Indian Penal Code soon. Friends, do not forget to like, share, and hitting bell icon before ending the video. Thank you.